Case number 241648. My notes indicate that the appellant is going to have arguments by Mr. Waterman, as well as the appellee will be represented by Attorney Michelle Rabe. Is that correct?
Yes, Your Honor.
All right, very good. All right, are you prepared to proceed, counsel?
Yes, Your Honor.
All right, go right ahead.
May it please the court, counsel. Bob Waterman for Enterprise. Your Honor, we're talking about a set of facts that are undisputed, a statute that is uncontroverted and nobody's questioning what it says, and we have a maximum penalty that the Iowa Utilities Commission can assess that states in 479B21 that maximum civil penalty shall not exceed $200,000 for any related series of violations. What we have in this case is Enterprise purchased a pipeline system in Iowa, 750 miles of pipeline. It purchased from MAPCO and Williams pipeline companies in 2002. And for over 20 years, it operated that pipeline under what it understood from the warranties at the time of sale that all state and federal permits were in place and valid. Now, Enterprise operates in 26 other states under federal permits, as it does in Iowa under a federal permit. At no time has it been assessed in Iowa for any safety violations, any issues with respect to that federal pipeline. In February 6th of 2023, the governor's emergency proclamation, which set aside rules for transport of propane in the state of Iowa for 30 days, expired. And we've cited to that proclamation in our opening brief, and we've also provided a copy of that proclamation to the court in our notice of additional authorities. The significance being of the significance of the product that Enterprise provides to our farmers and our citizens during the state of Iowa that would result in the governor taking such an emergency measure as to stop the hours of drivers and other things to ensure that people get their propane. The very next day after that proclamation expired, the Iowa Utilities Commission sent a show cause order to Enterprise saying, show cause why you should not be fined for not having an Iowa state permit. At which time Enterprise was, what? We didn't know we didn't have a permit. We were told we had a permit. It was warranted when we bought the permit 20 years ago. Nobody's ever told us we had a problem with our permit, and it immediately took steps to rectify, to find out everything it needed to know and to provide all the information it could to the Iowa Utilities Commission. The Iowa Utilities Commission set a show cause hearing in less than 6 weeks. Leading up to that show cause hearing, Enterprise said, could we get a 2-week extension so we could get local counsel involved? Denied. At the show cause hearing in March, less than 6 weeks after the notice, and 26 minutes later after the hearing, that's all it lasts, no sworn testimony was taken by the Iowa Utilities Commission, and several weeks later, or a month or so later, it issued its penalty of $1.8 million for, under, as I noted, the statute, it's supposed to be a $200,000 cap for any series of related violations. Enterprise said, wait a minute, we've got one pipeline, it's 750 miles, we bought it when it was one pipeline. How do you justify a $1.8 million penalty, which in fact was 5 times higher than any other penalty ever issued by the Utilities Commission? It was imposed again in less than 6 weeks following the first notice. It denied their request for an opportunity for an extension of time, and it's 9 times greater than the statutory cap. So Enterprise said, this is pretty heavy-handed, but we're going to continue to do everything we can to work with you, state of Iowa, including the day before the show cause hearing, they submitted an application for their state of Iowa permit for permit for one pipeline. And ever since then, they've been cooperating with the state of Iowa in order to get their pipeline permits in place. And as of today, 2 of 3 that it is now requiring have already been provided, so they're in compliance with, they have 2 permits, one for a western leg, one for an eastern leg, and a third permit is due any day. I cite to this, and I cited to it in our notice of additional authority because it shows the continuing good faith that Enterprise has been providing to the state of Iowa, not only in the products that it provides, but in its cooperation in doing everything possible to rectify this penalty. And what has, yes.
Throw this out there. My understanding of the reason that there were 9 permits for all of this pipeline in the first place was that this pipeline was constructed over a period of time, correct? And
It was constructed in the 60s by MAPCO and Williams Brothers in segments.
so well in advance before your client owned it, correct?
And our client bought it in 2002, and the pipeline, the federal government in the 8th Circuit decision of Kinley overruled Iowa's statute and found that that the federal government controls safety and all the issues relating to pipelines. And you have another question?
I do, because pipeline law is not something we see a whole lot of, but, my question is,
That was a repealed statute under which the 9 I'm sorry.
spit out my question here. So the district court, your argument is, if I'm understanding it right, and if I'm not, let me know, but your argument is that the district court erred in presuming that that Enterprise was required to have 9 permits for the pipeline and therefore committed 9 separate violations. Am I boiling it down too much?
Absolutely not.
Where do you preserve error on that?
We've done it throughout the briefing at the lower court. We've done it throughout our briefing at the appellate court, and there's never been any issue raised that error was not preserved.
The agency. I mean, in a 17A action, you have to preserve error both at the agency and the district court. And I don't see that the agency, so.
That's exactly where I was going.
Go ahead. And it's,
And that, in fact, it was preserved. It was preserved in the briefs at the agency level, and it was preserved in the briefs before the court, and it was preserved on appeal. And that's never been an issue that's been raised by opposing counsel.
maybe I can, the way I understand your argument, I think on appeal seems to be sort of 2-part. One is the interpretation of the statute question, and assuming that there were 9 violations, they're all related and so should come under the any related series cap. And then the second argument, and first of all, that first argument I see all throughout your whole case. It was at the district court, it was decided by the district court, it was at the agency, decided by the agency. But then the second argument is this sort of, it should have only been 1 violation in the first place, so we don't even get to that interpretation question. And that's the one that I'm concerned isn't preserved here.
That we only get to 1?
Right. That there's only 1 violation rather than 9 violations.
I believe it's preserved in our briefs, as I recall it. That's been front and center of, I believe, everything that we've been arguing since the agency decision. We did it at the lower courts level. We had it in our briefs there. We've had it in our briefs here.
Should ever rule on that question?
The commission found 9 violations based on 9 permits.
Right. Did you argue to the commission, we only needed 1, so you should have only fined us once?
Did. And in fact, when we first did our permit, we said, okay, here's our permit. We've now applied for 1 permit. We only need 1 permit. And then we went back and forth, as shown in our offer of additional authorities. They said, well, we want you to have 3. We want you to have 1 for a western leg, 1 for an eastern leg, and we want you to have 1 for your underground facilities. But it wasn't because of the number of pipelines or number of permits. It was because of administrative efficiency, and that's what they state in their orders. So I'm sorry if I'm missing your question, but all along, we've been saying one permit, we've got one federal permit, we only need one state permit, we only applied for one state permit. They came back and said, no, you need 3 for administrative efficiencies. So we've applied for 3, we've received 2, we've got 1 in the pipeline due any day. And we don't believe that the commission considered any of the factors that they're required to consider when determining the amount of a penalty. And those would include the gravity of the violation. Well, we had no knowledge of any violation. There were no safety issues. Sinclair, on an equal protection argument, we point to another pipeline company, had a hearing the same day, and it said, and it was fined $200,000, the maximum amount of its violation. We were fined 9 times that. So we believe, for all the cases cited, that constitutes a violation of equal protection. I see my light's off.
I'm going to have to cut you off there, sir. You will have 5 more minutes on rebuttal.
Thank you.
Counsel, whenever you're ready.
Court and counsel, I think right off the bat, in response to the court's line of questioning, it's important to point out that a thorough review of the record indicates that this issue of 1 pipeline versus 9 was not advanced until the district court. And even then, it was basically 1 sentence in the district court briefing that where Enterprise said it was no longer the case, quote, that the pipeline was previously permitted in 9 separate dockets. And then they referred to, quote, 9 separate violations by this single pipeline.
Claim, as I understand it, that they've been arguing this the whole time because they've said the fine's too much, that it's implicitly in there.
I think they are 2 entirely separate arguments, and I think they're the main arguments before this court. The first one is it 1 pipeline or is it 9? And I would note on that, as to that point, it's actually, as it was originally permitted and as the facilities exist today, it was 7 pipelines and 2 storage facilities. So in Enterprise's attempt to say this is 1 pipeline, that seems to just ignore the fact that 2 of these are storage facilities in eastern Iowa, which are not pipelines. They are covered under 479B in terms of permitting requirements, but they are separate. And then what was advanced at the agency level was that the cap should be $200,000. That was sort of asserted the entire time. But this step further of, wait a minute, the reason it should be capped is because it's 1 pipeline versus 9, that did not appear until the district court. And I think in their reply brief, there may have been a little bit more than in their original brief. But in response to, I can't remember if it was Judge Buller or Judge Chikelli, but one of you asked if the district court had ruled on that, and they really didn't. They kind of touched on it a little bit when they went into the issue of the maximum penalty cap, but they didn't.
Counsel, on the other argument, on the meaning of any related series of violation, you argue that the commission that should be considered sort of as an application of law to facts that's a little bit more deferential to the commission. Why isn't that, as a matter of statutory interpretation, just a correction of errors of that law that the commission doesn't get any deference to?
I think you could argue it either way. My position would be, especially given what the district court said about that area of law, I believe when they said it was the IUC's statutory duty to, it's our position, it's IUC's statutory duty to enforce the provisions of the chapter, and the district court specifically talked about the IUC's subjective discretion, as a quote, to determine the appropriate penalty when the law is violated. I think consistent with the recent Supreme Court case of Kashiki versus Summit, which talks about deferring to the Iowa Utility Board's interpretation of laws, because this area of pipeline regulation is not something that everyone's familiar with. It's more of a specialized area. So I think this could be considered a situation where it is within, the statutory interpretation is within the purview of the agency, which would be the standard of illogical, irrational, unjustifiable, rather than correction of errors of law. And I think in this case, no matter which no matter which standard you use, I don't think there was any misapplication of the law by the district court. The district court went through a very lengthy analysis of the fact that this was, that the statutory cap would apply to each pipeline would be capped at $200,000 because the cap operates to cap the number of days of a single violation rather than to cap all of the pipelines that someone might own. And the court was pretty clear that that's consistent with legislative intent. I would also argue that's consistent with common sense, because if you say that say you have 10 pipelines in the state of Iowa and you've got different issues with all of them, and maybe some of the issues are serious, maybe some aren't, but to say that the entire civil penalty that can be imposed is $200,000 when the statute specifically says it's $1,000 a day, which seems to indicate that the pipeline owners and operators need to show a certain level of attention to these type of violations. Had this cap not been in place, because this pipeline was unpermitted for 21 years, it is still not properly permitted as we sit here today, although the IUC acknowledges that Enterprise has taken steps to make that happen, and it does appear to be in the final stages of getting that done. It's not permitted as one pipeline now. This argument that it's one pipeline does not bear out with any of the facts, any of the underlying facts in the case.
A little bit about the other agency decisions that are used as comparators, and some of those are available electronically so we can find them. What do we do when we're looking at the total universe of things to compare to if there is reference such as to a document that we do not have access to electronically? I guess the gist of my question is, what is the total universe? Is it everything the agency's ever done? Is there some link to how we can find it, or is it whatever the parties tell us?
I think to some extent it's probably what the parties tell you and then what is in our briefs and maybe what's on Westlaw, for lack of a better answer. I can tell you in terms of the equal protection claim that the only case the IUC has ever had, the IUC has never had a case where something went unpermitted for 21 years. And without the statutory cap, it would be like $66 million would be the penalty for that. It's like almost 8,000 days of not having a permit. The Sinclair case is probably the closest. That's the one that the appellant has cited. That one kind of occurred at the same time as this one. That's when the IUC discovered that was another pipeline that was unpermitted, but that had been unpermitted for less than a year. I believe it was 333 days. So the IUC's position would be under the $1,000 a day, the maximum penalty would be the $333,000, but that's where the cap does apply, because it's the same situation as this one. It's a pipeline that was unpermitted for 333 days. It's one pipeline, so the cap would be $200,000. So Sinclair was fined at the same level as Enterprise was. It's just that it was one pipeline instead of 7 pipelines and 2 storage facilities.
So when you were describing how you think, or how the commission thinks the statute should be interpreted, that any related series of violations is for each pipeline, you use the word each, and your friend on the other side, points out that the statute doesn't say each, it says any. Each would seem to be more singular. Any is ambiguous, whether it's singular or plural. What do you make of that, and the fact that the statute does use the more ambiguous term?
The facts of this case lend itself to the interpretation advanced by the IUC and affirmed by the district court, that this is kind of the perfect example of that, where you have multiple pipelines out of compliance for a period of time, and each one of those penalties is capped at $200,000. I think you perhaps could have, it just sort of gets hypothetical, but could you have a situation where 4 things go wrong over a period of 2 days and a pipeline explodes? Are each of those 4 things subject to $200,000 each, or is that one, is the explosion one event that would cap the penalty at the $200,000? I think it's very fact specific. We don't have a lot of cases where we've, imposed penalties of this level. So it's kind of a hard one to answer in that sense. I think there are times when you could argue it either way, but I think the standard definition as discussed by the trial court, I believe that's also the PHMSA interpretation, that related series generally means a series of daily violations. So I'll just wrap up quickly. It's the IUC's position that the district court correctly concluded that the petitioner had failed to obtain the necessary hazardous liquid pipeline permits under Iowa Code 479B4 from the time it acquired the pipelines in 2022 until the IUC brought the matter to the petitioner's attention. And it's also the IUC's position that the district court's interpretation of the cap is supported by both record evidence and supported by the law. And the Iowa Utilities Commission, as Appellee, would ask that the district court's decision be affirmed.
All right, thank you, Ms. Rabe. Mr. Waterman, you have 5 minutes for rebuttal.
Thank you, Your Honors. Thank you. On the issue of preservation of air, Appellee's brief, argument 1, frames the issue as the district court correctly held that the Iowa Utilities Commission was within its statutory and discretionary authority in imposing the penalty in this case. Sub A, preservation of air. The commission states this issue was presented to the district court and petitioner's notice of appeal from the decision of the district court was timely filed. Therefore, the commission agrees that air has been preserved.
Fortunately for you, there's controlling case law that requires us to consider air preservation regardless of what your opponent has to say.
Thank you, Your Honor. And I think I've addressed it in response to your question, hopefully, as to where we believe the record contains evidence that air was preserved at all levels.
Okay, I guess I'll ask one more time. Where in the commission's ruling is the issue with only requiring a single permit?
I'm sorry, I'd be repeating myself to say it's in our briefs, and we've addressed it repeatedly from the beginning of the agency level all the way through the district court and the appellate level. Thank you.
Okay, but there's two parts to air preservation. One is that you argued it, the other is that it's ruled on. So where did the commission rule on it?
We believe the commission did rule on it in its ruling, and I don't have that in my hands, Your Honor. I apologize. If I may move on the issue of number of pipelines, Counsel noted the Summit Carbon Solutions pipeline, which I also believe is quite instructive here. It talks about the plain definition of pipeline found in 479B, and then it addresses the federal definition found in 49 CFR 195.2, and it defines pipeline as pipeline or system means all parts of a pipeline facility through which a hazardous liquid or carbon moves in transportation, including but not limited to line pipe, valves, other appurtenances connected to the pipe, pumping units, all of the above, everything that's connected to our 750-mile pipeline is exactly the way it's defined in here and the way the commission cited to this case in its position as to the same definition. I think the idea that you start to count underground facilities and other things as ways to double and triple, and in this case, take times 9 a penalty is not the way the statute is drafted, is not the way the statute is read. They're doing it under an old repealed statute. When it comes time to determining the amount of a penalty, whether you actually have to assess the full $200,000, which we think is the maximum penalty in this case, you're to consider such things as I began to note, gravity of the violation. In this case, we'd owned it since 2002. Former owners had represented all warranties, that everything was there. We believed that to be the case. We're never told otherwise, never received any notices from the state of Iowa relating to this pipeline, certainly nothing safety related wise. This was merely a paperwork error which, as I noted previously, Sinclair was only fined the $200,000 maximum amount. In terms of the good faith after notification, I mean, we've been working hand in glove with the commission ever since notification of this violation. We've done everything we've been asked to do. We've provided all the information, and as council has just conceded, the final of 3 permits is now due any day now. We think that all of the issues of good faith notification have been met, and that the court should reverse this decision and remand it for purposes of determining those factors, including the appropriateness of the penalty to the size of the pipeline company and the pipeline's conduct in this case, and ought to be reduced from the $200,000 level. It's our position it ought to be a 0 penalty. But if there's going to be any penalty at all, the district court on remand ought to be instructed to follow the terms of the statute in following what is the gravity of it, is it appropriate concerning the conduct, and the good faith shown by Enterprise in this case. And we ask that the court rule accordingly. Thank you.
And thank you both for your briefs as well as for your arguments this afternoon. We will consider this case submitted, and we will have a ruling out as soon as we are able.